Attention! If you're married to a U.S. citizen or planning to apply for a marriage-based green card, major changes are coming that could dramatically affect your immigration journey. Trump's new policies are reshaping the entire process, and what worked before may not work anymore. Stay with us because what you're about to learn could be the difference between approval and denial of your green card application. Welcome to U.S. Visa Info, your trusted source for the latest immigration news, updates, and guidance for anyone navigating the complex U.S. immigration system. I'm thrilled you're here today because we're covering a topic that affects hundreds of thousands of families across America and around the world. We're talking about Trump's new marriage-based green card rules and what every spouse needs to know to protect their immigration status and successfully obtain their green card. At US Visa Info, we break down complicated immigration policies into clear, actionable information so you know exactly what steps to take and what is a marriage-based green card to avoid costly mistakes. This information is absolutely critical for anyone in a marriage to a U.S. citizen or lawful permanent resident. So, let's dive right in. Marriage-based green cards have long been one of the most common pathways to permanent residence in the United States. Every year, tens of thousands of foreign nationals obtain green cards through marriage to U.S. citizens or green card holders. The process has always involved scrutiny to prevent fraud. But under the Trump administration's renewed immigration enforcement priorities, the rules have become significantly stricter and the scrutiny has intensified. Understanding these changes is essential whether you're just starting the process, waiting for an interview, or already have conditional permanent residence. Let's start with the fundamental question of what a marriage-based green card actually is. When a U.S. citizen marries a foreign national, the citizen can petition for their spouse to receive lawful permanent residence, commonly known as a green card. This allows the foreign spouse to live and work permanently in the United States. If the Trump-era policy changes explained couple has been married for less than 2 years at the time the green card is granted, the foreign spouse receives conditional permanent residence that's valid for 2 years. After 2 years, the couple must jointly petition to remove the conditions and convert it to a full 10-year green card. If the marriage has lasted more than 2 years before the green card is issued, the foreign spouse receives the full 10-year green card immediately without conditions. The process involves multiple steps. First, the U.S. citizen spouse files Form I-130, petition for alien relative with U.S. citizenship and immigration services known as USCIS. This establishes the qualifying relationship. If the foreign spouse is already in the United States, they can often file Form I-485, application to register permanent residence, or adjust status concurrently with the I-130. If the foreign spouse is outside the United States, they go through consular processing at a U.S. embassy or consulate in their home country after the I-130 is approved. Both pathways require extensive documentation, background checks, medical examinations, and interviews. Now let's talk about what's changed under Trump's new policies. The Trump administration has made combating immigration fraud a top priority, and marriage-based green cards are a major focus because they have historically been vulnerable to fraud. Fraudulent marriages where couples marry solely for immigration benefits without intending to build a genuine life together have been a long-standing concern. The new policies include enhanced scrutiny mechanisms, more intensive interviews, increased scrutiny in interviews, increased requests for evidence, stricter standards for proving a bona fide marriage, expanded grounds for denial, and heightened enforcement against fraud. One of the most significant changes is the interview process. Previously, not all marriage-based green card applicants were interviewed, and when interviews did occur, they were often relatively straightforward. Under the new policies, interviews are now mandatory for virtually all marriage-based cases, and these interviews have become much more rigorous. Officers are trained to detect fraud and will ask detailed, sometimes very personal questions about your relationship, your daily life together, your finances, your families, and your future plans. The interviews may be conducted separately with each spouse to check for inconsistencies in their answers. USCIS and consular officers are now asking much more detailed questions than before. You might be asked about how you met, where your first date was, who proposed and how, details about your wedding ceremony and reception, where you went on your honeymoon, what you did there, the layout of your home, which side of the bed each person sleeps on, what you had for breakfast that morning, whose family you spent the last holiday with, what gifts you exchanged for recent birthdays or anniversaries, details about each other's work schedules, what television shows you watch together, what your spouse's favorite food is, details about recent arguments or disagreements, and financial matters like who pays which bills. These questions are designed to trip up couples in fraudulent marriages who haven't actually built a life together and don't know intimate details. Spouses must prepare about each other. Another major change is the dramatic increase in requests for evidence known as RF. USCIS is issuing far more RF than in previous years, asking applicants to provide additional documentation to prove their marriage is genuine. An RF can significantly delay your case, and if you don't respond properly within the given time frame, usually 87 days, your application can be denied. Common items requested in RF include additional photos together from throughout the relationship, more joint financial documents, affidavit from friends and family attesting to your relationship, proof of trips taken together, correspondence between the spouses, and explanation of any inconsistencies in the application or supporting documents. The standards for what constitutes a bona fide marriage have also become stricter. Officers are looking for compelling evidence that you have commingled your lives in the way that genuine married couples do. This means they want to see that you live together, share finances, spend time together, have integrated your families and social circles, and are planning a future together. Simply being legally married is not enough. You must prove that your marriage is real and not just a transaction for immigration benefits. The types of evidence that are most convincing include joint bank account statements showing both names and regular activity by both parties, joint credit cards, joint lease or mortgage agreements with both names, utility bills in both names at the same address, joint car insurance or health insurance, life insurance policies naming your spouse as beneficiary, joint tax returns filed as married filing jointly, photos together throughout the relationship, including with each other's families, travel documents showing trips taken together, affidavit from people who know you as a couple, birth certificates of any children born to the marriage, and correspondence such as emails, texts, or letters, especially if you had a period of long distance relationship. What's particularly important to understand is that officers are now looking for red flags more aggressively. Certain situations automatically trigger heightened scrutiny, large age gaps between spouses, significant differences in education or socioeconomic background, short courtships before marriage, marriages that occurred shortly after the foreign spouse received a denial of another immigration benefit or was placed in removal proceedings. Situations where the couple doesn't speak a common language fluently, marriages where the couple has spent very little time physically together, prior immigration violations by the foreign spouse, and situations where either spouse has been married multiple times before, especially if previous marriages also involved immigration petitions. If any of these red flags apply to your case, it doesn't mean you can't get approved, but it does mean you need to provide especially strong evidence of your genuine relationship. The consequences of fraud have also become much more severe under the Trump administration. If USCIS or the State Department determines that a marriage is fraudulent, the immigration benefits will be denied. But that's just the beginning. Marriage fraud is a federal crime under U.S. law, punishable by up to 5 years in prison and fines up to $250,000. Both the U.S. citizen and the foreign spouse can be prosecuted. The foreign spouse will likely be placed in removal proceedings and deported and will be permanently barred from receiving any future immigration benefits. The U.S. citizen can also face criminal charges and will be barred from ever successfully petitioning for another spouse. Immigration and Customs Enforcement, known as ICE, has increased investigations into suspected marriage fraud cases. They may conduct home visits to verify that couples actually live together. These visits can happen unannounced. ICE agents may knock on your door early in the morning or late at night to see if both spouses are present. They may look for evidence of cohabitation, such as both people's belongings, photos together, mail address to both parties, and other signs of a genuine marital household. For couples who receive conditional permanent residence, the process of removing conditions has also become more difficult. Remember that if you've been common reasons for denial married less than 2 years, when your green card is approved, you receive a conditional 2-year green card. 90 days before that conditional period expires, you must file Form I-751, Petition to Remove Conditions on Residence. This must be filed jointly by both spouses, and you must prove that your marriage is still genuine and ongoing. Under Trump's policies, I-751 applications are facing much longer processing times and much higher rates of interviews in RF. Speaking of domestic violence, this is an important exception to be aware of. If you're in a marriage-based green card process and you're experiencing abuse from your U.S. citizen or permanent resident spouse, you may be able to self-petition under the Violence Against Women Act, known as VAWA. Despite its name, VAWA protections are available to victims of any gender. A VAWA self-petition allows you to apply for a green card without your abuser's cooperation or knowledge. Let's talk about some specific scenarios and how Trump's new rules affect them. If you're engaged to a U.S. citizen and planning to come to the United States on a K-1 fiancé visa, you should know that these visas are also facing increased scrutiny. The K-1 allows a foreign fiancé to enter the U.S. for 90 days to marry the U.S. citizen petitioner. The Trump administration has increased denials of K-1 visas and the subsequent adjustment of status applications. If you entered the United States on a different visa, such as a tourist visa or student visa, and then married a U.S. citizen, your case will receive extra scrutiny. While it's not illegal to marry on a tourist visa and then adjust status, officers will scrutinize whether you had immigrant intent when you entered. If they believe you entered on a non-immigrant visa with the preconceived intent to marry and stay, they could find that you committed visa fraud. For couples where the U.S. citizen spouse is currently living abroad with their foreign spouse, you have the option of consular processing rather than adjustment of status. This involves the foreign spouse attending an interview at the U.S. Embassy or consulate in their home country. Consular processing has some advantages, such as generally faster processing times, but it also has risks. The 3-year and 10-year bars are particularly important to understand. If a foreign national accrues more than 180 days of unlawful presence in the United States and then leaves, they're barred from returning for 3 years. If they accrued more than 1 year of unlawful presence, the bar is 10 years. These bars can be devastating for marriage-based cases. There is a waiver available, Form I-601A, but you must prove that your U.S. citizen or permanent resident spouse would suffer extreme hardship if you're not allowed to return. Now, let's discuss some practical steps you should take to strengthen your marriage-based green card application under these stricter rules. First and foremost, document your relationship thoroughly from the very beginning. Take lots of photos together and with each other's families throughout your relationship. Keep records of communication, especially if you had a long distance period. Save plane tickets, hotel reservations, and other evidence of time spent together. Maintain joint financial accounts and make sure both of you are actively using them. Second, be completely honest in all your applications and interviews. Never lie or omit information, even if you think it might hurt your case. Immigration officers are trained to detect deception, and if they catch you in a lie, your case will almost certainly be denied and you could face fraud charges. Third, prepare thoroughly for your interview. Review your application and all supporting documents before the interview. Make sure you and your spouse are familiar with all the information you provided. Practice answering common interview questions together, but don't memorize scripted answers because that can come across as rehearsed and suspicious. Fourth, respond promptly and thoroughly to any requests for evidence. If you receive an RF, don't panic, but do take it seriously. Read the request carefully to understand exactly what's being asked for. Gather all requested documents and consider providing additional supporting evidence beyond what was specifically requested. Fifth, maintain your relationship and your evidence throughout the process. The immigration process can take many months or even years, and you need to continue building evidence of your bona fide marriage throughout this time. Keep taking photos together, maintain joint finances, continue living together, and document your shared life. Sixth, be aware of public charge considerations. The Trump administration expanded the public charge rule, which makes it harder for people who are likely to depend on government benefits to get green cards. The U.S. citizen spouse should be prepared to demonstrate financial ability to support the immigrant spouse through Form I-864, How Couples Can Protect Their Case Affidavit of Support. Seventh, understand the importance of legal representation. Immigration law is extremely complex and the consequences of mistakes can be severe. While it's not required to have an attorney, having experienced legal counsel can significantly improve your chances of success, especially if your case has any complicating factors. Let me address some common mistakes that people make in marriage-based green card applications. One of the biggest mistakes is failing to provide sufficient evidence of a bona fide marriage. Some couples submit only the bare minimum required documents and then are surprised when they receive an RF or denial. Provide abundant evidence from the beginning. Another common mistake is inconsistencies between the application and the interview. Make sure both spouses review the application carefully before the interview and that you're both telling the same story. Some couples make the mistake of not living together or not commingling their lives sufficiently. Many people also underestimate the interview and don't prepare adequately. What about same-sex marriages? The good news is that since the Supreme Court's decision in Obergel versus Hodges in 2015, same-sex marriages are recognized for immigration purposes just like opposite-sex marriages. For couples with significant age differences, you'll face extra scrutiny but can still succeed with compelling evidence. For couples who met online, document your online relationship thoroughly with chat logs, emails, and video call records. Processing times for marriage-based green cards have increased significantly. If you're adjusting status within the United States, you can currently expect the total process to take anywhere from 12 to 24 months or even longer. For removing conditions on residence through Form I-751, current processing times are extremely long, often 18 to 36 months or more. That brings us to the end of today's comprehensive overview of Trump's marriage-based green card rules here at US Visa Info. I hope this information has given you a clear understanding of what to expect, how to prepare, and how to give yourself the best possible chance of success. The marriage-based green card process has always required careful preparation and substantial evidence. But under the current administration's policies, it's more important than ever to be thorough, honest, and well-prepared. If you found this video helpful, please give it a thumbs up and subscribe to US Visa Info so you don't miss any important immigration updates. Hit that notification bell to get alerts whenever we post new content about visas, green cards, citizenship, and other immigration topics. Share this video with anyone you know who's going through the marriage-based green card process or considering starting it. Do you have questions about marriage-based green cards or your specific situation? Drop them in the comments below and I'll do my best to provide guidance. Also, let me know what other immigration topics you'd like us to cover at US Visa Info. Your feedback helps us create content that truly meets your needs. Thank you so much for watching US Visa Info. Remember that while the marriage-based green card process has final tips and key takeaways become more challenging, hundreds of thousands of people successfully obtain green cards through marriage every year. With proper preparation, thorough documentation, and honest representation of your genuine relationship, you can too. Stay informed, stay prepared, and we'll see you in the next video right here at US Visa Info. Good luck with your immigration journey.